There appears to be none. Brett Hudson.
Thank you, Mr Chair. It's wonderful to be able to speak again on this, the Shop Trading Hours Amendment Bill, because the great theme of tonight is about choice, and I'll take the time again to talk about how this bill actually provides that choice. But one of the first ways it's illustrated, actually, Mr Chair, is many members have made comments tonight about the National Caucus being whipped to vote in a certain way. I think, and I contend that those members opposite don't actually understand choice and how choice can be exhibited. You see, because as a member of the caucus, I can assure them what happened. Members in a caucus meeting discussed this matter, and individually we agreed that we would permit our whips to express our votes by proxies. We have chosen that we have chosen that we will support this bill and that we will have our whips express those votes for us, except for those of us lucky to be in the chamber, of course. When the vote's taken, we'll mark our names off in the customary way. But more than that, the bill is all about choice. It provides choice to families. Those families that want to shop on Easter Sunday where it is permissible can do so. Those that do not wish to won't have to. Those employees that do not want to work on Easter Sunday will not and cannot be forced to. Local communities that want shopping available in part or all of their communities will be able to. Similarly, local communities that do not want retail open or trading on Easter Sunday will be able to maintain what is probably the status quo for them and not permit that to happen. Authorities have choice in how and whether to, one, seek a change to the default position and then in the process of how they consult with their communities. This bill is all about choice. One thing that I find very troubling about elements the members have raised, because the amendments to Section 5 of the Principal Act are very clear that employees' rights to refuse to work on this day for reasons of their own which they do not have to express or justify are protected. They are protected with the full force of employee protections under New Zealand statute. And yet tonight we have heard, as we have in previous readings, members opposite claim that those protections will have no force, no effect, that employees will be too scared to use them. What they have actually been saying, in effect, is that employee protection in New Zealand doesn't work, full stop. So clearly their view is that we have an amount of legislation on our books that simply doesn't work and can never work because employees will always be too scared to use it. What I contend, Mr Chair, is what they are really saying is they do believe in those protections when it suits them to, but they don't believe in that those protections will work when it's a measure put forward by this government. I think that's quite sad. But overall, it's coloured even further by taking that position that, in effect, what they are seeking to do is limit choice. Whereas this government, this party, the party of choice, the party of free will, is saying, let's give our communities the opportunity to make their own decisions. Because ultimately, if I look at all the dealings that I've had with councillors, whether they're city, district, regional councillors, they all believe that local communities should have a voice, should have a say in how their communities operate, what's available, what's not. So it's quite interesting, actually, that because members have pointed out that a number of the authorities or representatives of the authorities said that they wouldn't necessarily want things done this way. Some expressed a view that Parliament should just do a blanket set of regulations for all of New Zealand, which is odd, really, because that is the antithesis of giving local communities a choice. You simply get central government to give one edict which was not going to, I'm sure, please everyone everywhere. But the other part I would note, and particularly to those representatives from those authorities, is that if one wants to have the authority to make decisions, particularly across a broad range of areas, one has to accept that you have to deal with the tough decisions and not just the easy ones. And I would note that not one of those authorities that were saying that they didn't want this addressed in this manner, not one of them were offering to relinquish the general competence authority granted to them in the early 2000s. And my message to them is, if you want to make decisions, if you want the authority to make calls in your community, you have a responsibility to deal not only with the easy problems, but also the tough ones.
Before I call Adrian Rurewhai, I have yet another leave to seek, and the leave that I'm now seeking is, which again, it is my understanding was the intention of the House when it was circulated, is that part 2 and the schedule, standing part, be taken as one question. Is there any objection to that? There appears to be none. I think we've got there. Adrian Rurewhai.
Thank you, Mr.